Hey guys, Sithis here, and in this video I'm going to explain why we should abolish intellectual property. The dictionary definition for intellectual property is a work or invention that is a result of creativity, such as a manuscript or a design to which one has a right and for which one may apply for a patent, copyright, trademark, etc. In other words, it is when the state grants a monopoly privilege over an idea, allowing the restriction of others to copy that idea using their own private property. For instance, if you create some sort of invention or art and are approved for a patent for that art, any other person that uses their property to copy that idea can be taken to court by the patent holder and punished by the state, whether it be by a fine, restitution, or jail time. This is a violation of private property rights because the definition of ownership is the right to control a scarce resource. If you are the owner of a scarce resource, you have the right to do whatever you want with that property so long as you are not using it to violate the property right of another individual, i.e., initiate an aggression. Intellectual property is not real property because an idea is not a scarce resource. Therefore, there could be no conflicts over its use. Conflicts are a dispute over scarce means. Scarce resources cannot be used by two people at the same time. If there's a watch and two people, both of them can't wear that watch at the same time. An idea is not a scarce resource in which you can have conflicts over. Two people can both use that same idea at the same time without taking anything away from the original creator. Let's say you do have an idea for a piece of art or invention, are approved for a patent, and put that product on the market. How can you stop another person from copying your work without initiating an aggression? In the end of the day, when you have a patent, you are stopping others from doing what they want with their private property. Also, if an idea is really property, why limit the amount of time in which you can own it? You can only own a patent for a limited amount of years depending on the country. If you own something, you have the right to control that resource until you either voluntarily trade that thing with another person or die. Then that property will return to the commons. You either have the right to control that scarce resource or you don't. If an idea was truly property, no one would have the right to restrict you from owning it for the rest of your life and passing it on to another person before you die. I don't know any intellectual property advocate who would actually support not only allowing a person to own a patent for the rest of their life, but pass it on to another person so that they can own it for the rest of their lives, then on and on into infinity. Although this position may be consistent, I think we could all see why that would be completely absurd. Copying is not theft. For instance, if you own a car and in the night I hotwire your car and steal it without your consent, have I violated your property rights? Of course I have, because I stole your property. By possessing your car without your consent, I'm claiming ownership over your car and are excluding you from it, which is a violation of property rights. Now let's say you have an idea for a new invention and decide to produce it and put it out on the market. Because I like your product, I decide to use my own private property to copy it. Have I violated your property rights? No, because you still have the idea in your head and nothing is restricting you from continuing to create the product in which you invented. Me copying your idea does not exclude you from using or producing that idea. Now let's say I decided to take a copy of your invention and sell it. Have I violated your property rights then? No, because you still have the idea. The only thing in which I decided to sell is my own property, which you have no right to. Your idea and the ability to produce it is still present. Me copying and selling my own property does not restrict you from accessing the idea in which you created. Nothing that was in your possession before was taken from your possession simply because I used my property to copy your idea. Now the question that I normally get is, if another person is able to copy my invention, what is going to incentivize me to create an invention if another person is able to copy it and possibly steal my profits? If there's a need for your product, someone will be willing to pay for that product. And because you are the first person to create it, that gives you the first seller's advantage. The first seller's advantage, also known as the first mover's advantage, refers to the benefit gained by the first company to enter a market or produce a new product. They often establish brand recognition, customer loyalty, and secure distribution channels ahead of competitors. This can create barriers for later entrants, giving the first mover a competitive advantage in the market. When a company is the first to enter a market or introduce a new product, it often enjoys several advantages. Being the first to market allows a company to establish its brand before competitors, making it more recognizable to consumers. Early adopters of a product or service may develop loyalty to the brand, making it difficult for competitors to win them over later. First movers can also secure advantageous distribution agreements, making it harder for later entrants to access prime shelf space or distribution networks. Furthermore, being the first allows a company to learn from its initial mistakes and refine its product or service. making it difficult for competitors to catch up. As you can see, because of the first seller's advantage, it is more than possible to make a profit off of an invention or a piece of art without a patent or a copyright. Another question that I get is there really no way in which I could prevent another person from copying my idea? There are plenty of free market ways in which you could use in order to prevent another person from copying your idea. Here's 3. 1. Non-disclosure agreements, or NDAs. NDAs are legal contracts that protect the confidential information shared between parties. They can be used when disclosing your invention or idea to potential investors, partners, or employees to prevent them from sharing or using the information without permission. 2. Trade secrets. Keeping certain aspects of your invention or idea confidential can protect them as trade secrets. This can include formulas, processes, or customer lists that provide a competitive advantage. 3. Encrypting files and documents. You can utilize encryption software to encrypt files and documents containing sensitive information about your idea. This ensures that even if unauthorized individuals gain access to these files, they cannot decipher the contents without the encryption key. As you can see, there are plenty of ways to protect your ideas or inventions without copyright or a patent. The idea that we have to violate people's property rights in order to protect our ideas, a non-scarce resource, is simply incorrect and immoral. Also, for all the people who are probably wondering, what about drugs? Don't pharmaceutical companies need patents in order to make a profit off of their drugs? To answer this, I want to show you a clip from a debate Stephen Kinsella did where he addresses this very question. Check this out.
Monopoly grants of privilege. As for pharmaceuticals, the idea, first of all, anyone who's interested, you can't do this while we're debating, but you should read Chapter 9 of Bolger and Levine's book, Against Intellectual Monopoly. They completely explode all the myths about the pharmaceutical industry needing patents and requiring patents. So let's take COVID as an example. Right now, there's 11 different vaccines that have been approved for emergency use somewhere in the world. And as of December 2020 last year, there were over 200 vaccine candidates of COVID being developed, and at least 52 were in clinical or human trials. So there's lots of innovation going on, and Moderna on October 20 waived its patent rights. So if it needs a patent to recoup its costs, why did it waive its patent rights? Look, Italy and Switzerland didn't even have drug patents until the late 70s, and they were some of the leading creators of drugs. Just as an example, Bolger and Levine, they did a study. They looked to a poll at the British medical journal's readers on the top medical milestones in history. They found that almost none of them had anything to do with patents. Penicillin, X-rays, tissue culture, anesthetics, chlorprom, I can't read that one, public sanitation, germ theory, evidence-based medicine, vaccines, birth control pill, computers, oral rehydration therapy, DNA structure, monoclonal antibody technology, and the discovery of the health risks of smoking. Of the top 15 entries, only 2 had anything to do with patents. And the Center for Disease Control in the U.S., they had a list of the top 10 public health achievements of the 20th century. None of them had anything to do with patents. A review of the most important pharmaceuticals reveals that many came about without the motive or the possibility of requiring a patent, including like aspirin, AZT, cyclosporine, digoxin, ether, fluoride, insulin, medical marijuana, methadone, morphine, oxytocin, penicillin, phenobarbital, prontosil, quinine, Ritalin, salvarsan, vaccines, and vitamins. So you don't need patents to develop drugs. Thanks.
If the only way that you can make profit off of your invention or art is to violate people's property rights, then your product shouldn't be on the market. To quote the great Stephen Kinsella, "Your failed business model is not my problem." To sum up, an idea is a non-scarce resource. Therefore, there could be no conflicts over its use. Any use of the state to stop another person from copying your idea, whether by patents, copyright, or trademark, is a violation of private property rights. There are plenty of ways in which you can make profit off of your ideas without violating people's property rights, as well as numerous free market ways to protect your ideas without the initiation of force. This is just a few out of the many reasons why I and many other anarcho-capitalist libertarians believe that intellectual property is a violation of private property rights and should be completely abolished. To finish this off, I want to show you another clip from the debate that Stephen Kinsella was in, where he basically lists off a bunch of times in which intellectual property has been abused in some pretty wild ways. Check this out.
Passed similar laws which we have now. So let's talk about copyright. Copyright has its origins in censorship and thought control, so it's no wonder that's what it still does today. So I'm going to give some examples. These are just some examples, and I'm going to go to some data in a little bit. So the seminal German silent film Nosferatu, which some of you may have heard of and even seen, was deemed a derivative work of Dracula, and courts ordered all copies destroyed. Now, luckily, someone preserved a copy, and that's why we still have it today. Shortly before his death, the author J.D. Salinger, author of Catcher in the Rye, convinced U.S. courts to ban publication of a novel called 60 Years Later, Coming Through the Rye. It was a sequel, unauthorized, and it was a derivative work, and copyright law prevented the publication of a book. There was one time, about 2005, a grocery store in Canada mistakenly sold 14 copies of the new Harry Potter book a few days before its official release. And so a British Columbia Supreme Court judge ordered customers not to talk about the book, copy it, or even read it before its official release date. Copyright also threatens freedom on the internet, which is very serious because the internet is one of the most important tools we have in the fight for freedom, to fight state tyranny. And just a few years ago, the Stop Online Piracy Act, or SOPA, was only narrowly defeated by an uprising on the internet. Aaron Swartz, who some of you may have heard of, was a brilliant young inventor of RSS, the technology behind blogging and podcasting, and he was an anti-SOPA activist. He uploaded some academic journal articles to the internet, and he was facing life in prison for federal copyright infringement, and he killed himself. A guy named Gilberto Sanchez bought a copy of an unfinished version of the 2009 movie X-Men Origins Wolverine in the Bronx, uploaded it to the internet, and was sentenced to a year in federal prison. There was a grad student in Britain named Richard O'Dwyer who had a website with hyperlinks to other people's pirated movies, and the U.S. went after him and finally got a judge to order him to be extradited to the United States to face federal prison. He finally escaped it, but his life was almost ruined and derailed for many years. In 2011, there's an interesting paper by law professor John Taranian where he talks about how the normal activities, because of the statutory damages clause of copyright that I mentioned earlier, up to $150,000 per infringing act. A typical internet user, like an average American law professor, like maybe named Richard, who doesn't even engage in P2P file sharing, could theoretically result in up to $4.5 billion in liability annually for copyright infringement. And if you might remember the singer Susan Boyle, the singer Susan Boyle from American Idol was prevented from singing a song because of copyright. Now, patent law, let's take some patent law examples. Patent law is rooted in protectionism, so it's no wonder that's what it does today. It protects people from competition. Back in 1999, at the dawn of e-commerce, Amazon had a patent on one-click, which was clicking once to complete an order. And they sued Barnes & Noble right at the beginning, right before the Christmas season, for daring to let its customers complete a purchase with a single click. By the way, these are not abuses. These are how the laws work and are supposed to work. In 2008, a patent holder threatened to use court injunctions to force Ford not to use various technological safety measures like active park assist, stability control, blind spot detection, and hands-free voice control. So this is another example of how patents can prevent safe measures from being implemented and can cause injury or death. And by the way, Professor Epstein's all in favor of patent injunctions because, after all, if it's a property right, you need to enforce it. Here's another one. Even though the practice of saving seeds after a harvest to plant the next season is as old as farming itself, patents prevent farmers from saving patented seeds. Monsanto and others even come after farmers for growing patented crops just because the wind carried it from a neighboring farm. Back in 2010, there were people who were literally dying who had Fabry's disease, and they could be treated with a drug called Fabrazyme made by Genzyme. It was in very short supply because it was being sold in Europe for a higher price. No one else could make it because of the patent. Another example of how patents kill people. And for a more recent example, some of you may know this. It always turns to Bitcoin, by the way, in Gene's opening remarks. On Saturday, Taproot was activated, which implements something called Schnorr signatures in Bitcoin, which is going to make it much more secure, more efficient. For 12 years, we've had Bitcoin, and we haven't had this because of a patent, which expired right before Bitcoin came out.
All right, guys, thank you guys so much for watching my video on intellectual property and, my little essay/paper on why we should completely abolish intellectual property. I want to give a shout out to Stefano for helping me out with the script and giving me his opinion on it. He's a really cool guy. I also want to thank Stefan Kinsella for giving me a lot of the information in this video, as well as Liquid Zulu. Liquid Zulu and Stephen Kinsella, those two guys really put me on to a lot of the ideas that I put into this video. So, you know, I want to give a huge shout out to both of them. Be sure to check out Liquid Zulu's YouTube video on abolishing intellectual property, as well as checking out Stephen Kinsella's book on abolishing intellectual property, or against intellectual property, if I'm not mistaken, that's the title. Or anything by Stephen Kinsella when it comes to intellectual property or just property in general. The dude is just amazing and is an intellectual. You could learn a lot of information from him. So without further ado, I just want to say thank you guys for making it to the end of this video. You guys are awesome. Please be sure to drop a like, be sure to drop a comment, be sure to help me out in the algorithm. Do all the good things that help me in the algorithm, and I'll see you guys all next time. Have a good night, guys.